All right, let's dive right into this explainer and build a clear, structured roadmap for mastering the complex, but honestly fascinating, legal doctrine of vicarious liability. If you're an A-level law student, or really just someone trying to grasp exactly how the law decides who takes the blame for workplace accidents, you are definitely in the right place. We're going to build your revision notes slide by slide, so let's get started. We've got a lot of ground to cover today. Here is our agenda. We'll start with what vicarious liability actually is, move through the two-part legal test of employment status and course of employment, look at crimes and intentional torts, and wrap up with modern gig economy implications. Okay, part one. What actually is vicarious liability? And why do we call it the strict liability of employers? So, in precise A-level terms, vicarious liability is basically a way of imposing strict or no-fault liability onto someone, usually an employer, who didn't personally commit the tort. Think of it less as a specific tort claim, like negligence, and more like a mechanism. The employer hasn't actually done anything wrong themselves, but the law still holds them fully accountable for what their employees do. Let's look at how this works in practice. For a victim, let's call him victim B, to successfully sue an employer, employer C, two big questions about employee A have to be answered with a solid yes. First, is A actually employed by C? And second, was A acting in the course of their employment when they injured B? Both of those boxes have to be ticked. Otherwise, there's no lawsuit against the employer. Now, you're probably thinking, why on earth is this fair? Well, the law justifies this rather harsh rule mostly because employers typically have what we call deep pockets. They have the public liability insurance needed to actually compensate victims. Plus, it pushes employers to really take responsibility. If you know you are on the hook for your staff's mistakes, you're going to hire much more carefully, train them properly, and keep a tight grip on internal discipline, right? Moving on to part two, test one, employment status, where we establish the relationship. Courts used to rely on a whole bunch of different tests to figure this out, but the modern go-to is the economic reality multiple test. This comes straight from the 1968 case Ready Mixed Concrete. To prove someone is an employee, you need to check off these three specific conditions laid out by McKenna J. 1, the worker provides their work or skill in return for a wage. 2, they accept the employer's control over how they do the work. And 3, all the other contractual details, like who provides the tools or pays the tax, are actually consistent with a true employment relationship. Next up, Section 3, relationships akin to employment in the modern workplace. Grab your revision tables for this part. We're looking at relationships of employment or things akin to it. Top row, we have the 2016 case Cox versus Ministry of Justice. Here's what happened. A prisoner working in a prison kitchen dropped a heavy sack of rice right onto a catering manager, injuring her. The legal significance here? It's massive. The Ministry of Justice was held liable, even without a formal employment contract, because the prisoner's activity was carried out on behalf of the defendant's operation, which created the risk. Contrast that with the bottom row, the 2020 Barclays case. Barclays required job applicants to get medical exams from a Dr. Bates. He was totally self-employed, an independent contractor. When claimants later alleged he assaulted them, Barclays was found not liable. This perfectly illustrates the independent contractor defense. If the wrongdoer is genuinely independent, the employer gets to escape vicarious liability. All right, Section 4, Test 2, Course of Employment. Was it actually part of the job? Let's fill in your second table, looking at the course of employment. We're comparing two really different outcomes here. On the left, we've got the Prohibited Act principle from Rose v. Plenty in 1976. A milkman was explicitly told not to use child helpers. He completely ignored this, used a boy to help out anyway, and the boy ended up injured due to the milkman's negligent driving. The employer was actually found liable. Why? Because the milkman was still executing his contractual duty, delivering milk, just in an unauthorized way. But look at the right side, the frolic of their own principle in Shelbourne v. CRUK. Picture this. An intoxicated scientist at a work party tries to lift a colleague, drops her, and causes a serious back injury. Here, the employer was not liable. The legal significance is that the employee was on a frolic of his own. His actions had absolutely nothing to do with his actual work duties. Sticking with that second table, what about crimes closely connected to employment? The huge leading authority here is Mohamud v. WM Morrison Supermarkets from 2016. In this one, a petrol station worker hurled abuse at a customer, followed him out onto the forecourt, and violently assaulted him. The Supreme Court found Morrisons liable. The legal significance you need to note down is that courts apply the close connection test quite broadly. Since the employee's job involved interacting with customers, his wrongful conduct was deemed sufficiently connected to his position, making it fair to hold the employer responsible. Moving right into Section 5, Crimes and Intentional Torts, and taking a deeper look at that close connection test. Let's apply that close connection test to intentional torts. We have to look at the incredibly tragic 2002 case of Lister v. Hesley Hall. A boarding school warden abused children who were under his care, and the House of Lords held the employer liable. From a purely legal standpoint, the significance here is that deliberate, unauthorized wrongdoing, even for personal benefit, can still trigger vicarious liability if it's inextricably linked to the duties the employee was entrusted with. It was his very role as warden that gave him the authority and access to commit those torts. And to finish off that second table, we need to ask, what if an employee is just pursuing a personal vendetta? Look at WM Morrison's Supermarkets v. Various Claimants from 2020. A seriously disgruntled employee intentionally leaked the payroll data of 100,000 colleagues online purely to damage the company. The Supreme Court found Morrisons not liable. Make sure you memorize this principle. The employer escapes liability because that wrongful disclosure was an independent personal vendetta. It was not an act closely connected to what the employee was actually authorized to do.
Finally, Section 6, Modern Implications and the Gig Economy.
You see these battles in the news all the time now. App-based companies like Uber heavily construct their business models on the claim that their workers are entirely self-employed independent contractors. Remember that Barclays case we put in our first table? That is exactly the independent contractor defense in action. By defining workers as strictly independent, these companies are trying to block any vicarious liability for accidents from passing up the chain to the corporate level. So, I'm going to leave you with this question. If the whole justification for vicarious liability, like we discussed at the very start, is about who exercises control and making sure victims get compensation, is the law actually keeping up? When algorithms are dictating almost every move a worker makes, is it time for this legal roadmap to evolve once again? Thanks for joining this explainer, and definitely keep reviewing those case tables.